amendment in the section 26 of the Arbitration Act shall apply prospective ban or retrospective ban. As a result of that, there was an amendment by the authorities who have succeeded before the amendment. But under section 34 of the Act, unconditional stay in certain circumstances. So, because of the judgment, there was this amendment. This amendment, according to the different respect, is of no consequence in this respect. Therefore, one hand, under section 36, where the regulation is made for stay of order, what has been granted discretionary powers. What has to verify whether what is in stay for certain terms and conditions or what is stay. If their power is there, then it is additional power that the prima facie case what is satisfied with the fraud, not in contract, not in induced, not in induced or related by fraud or corruption. How can these findings be given at the stage of stay? Stage of stay. Stage of sometimes prior to that. So this closure should be related to avoid inconsistency between 36 earlier part and second part. Thereby, suggestion that order refusing to grant or granting stay to the operation of the court and an application under section 36(2) shall be made applicable. What is happening is that when you apply for stay under section 36, the court grants stay or refuses to grant stay. The question arises that this is not an applicable order under section 36. So, what if this order will go to Supreme Court under article 36? This is interlocutory order, and there is a appeal provided to section 37 arising out of order 17, under 19, under 9, and 9. If stay has been rejected or allowed, there is no appeal under section 37. 37 shall the amendment so as to include this power. Similar power shall be granted to appellate court under 37. Court shall have power to modify the order by allowing that it is rejected by the arbitral judge and also rejected by the other single judge. Limit of jurisdiction shall be provided for filing and appeal under section 37. Khambhatta of the Arbitration described under section 13 of the Commercial Court Act. If for in case of government of Maharashtra versus Borsar others, took a view what should be the limit of limitation if appeal is filed under section 37 arising out of the grounds mentioned there, or what is the period of limitation in case of appeal arising out of Commercial Court Act. Commercial Court Act provides for 60 days limitation. Unfortunately, under section 37 there is no period of limitation prescribed. Supreme Court interpreted section 34(3), article 116, article 117 of the Arbitration Act, and took a view that if appeal is arising out of or filed under section 37, then regulation will apply. Regulation will 116 or 117 intra-court appeal or appeal arising out of the lower court will apply. Whereas in the case of Commercial Court, 2 months period prescribed under section 13 will apply. To avoid this inconsistency, my suggestion is that even in section 37 of the Arbitration Act, it shall be provided that appeal can be filed within 60 days, so that both the provisions are conformity with each other. There are more suggestions as to section 38 in provision, in provision to section 38, it shall be made clear that the arbitral proceedings are terminated with non-payment of arbitrator's fees by the claimant in respect of claim or by the respondent in respect of counterclaim. Arbitration agreement cannot be invoked again in respect of such claim or counterclaim till such payment is made to the arbitrator. This is of course for the benefit of arbitrators, because the party who doesn't want to pay, he is liable to pay, to continue. Arbitrator will have no option either to suspend the proceedings or to terminate the proceedings. Normally proceedings are terminated. Whatever work is done by the arbitrator, whatever there is case. We should be paid this fees. It should not can again invoke section 11 and apply for appointment of fresh arbitrator. So my suggestion is that if it is terminated on this ground, then he should not be allowed to invoke arbitration again unless the fees of the arbitrator is first paid. Then section 39, my suggestion is that arbitrator shall be entitled to make an application under section 39 before the court for an order and direction against the defaulter for such payment. One of my colleagues told me that matter is settled out of court. You file consultants before the arbitrator and one party pays, other doesn't pay. He says, now matter is settled, why should I pay? And he is avoiding you. Now, arbitral tribunal does not have any recovery agents for recovery of the fees of arbitrator. In that type of situation, what do you do? So my simple suggestion is that arbitrator should be allowed to make an application under section 39 to the court for making a direction to the parties to pay the fees of the arbitrator. Then section 43A to 43M, which provides for appointment of Arbitration Council of India. Though these provisions are inserted, they are not notified. My suggestion is that at some point of time it should be notified. Section 87, which is struck down by Supreme Court in case of Hindustan Construction versus Union of India, shall be restored. And the last suggestion is about the 8th schedule, where qualification and experience of an arbitrator prescribed is omitted for some reason. Now I can't understand what is the purpose of omitting the qualification of an arbitrator. Because arbitrator has to decide everything, obviously. Both parties are likely to argue issue of jurisdiction, limitation, arbitrability, res judicata and whatnot. Even oral evidence will have to be laid. So if a layman who is not familiar with law or even basic law, I am not suggesting that he should be advocate of 10 years standing. With some modification, 8th schedule should be restored, that is my suggestion. My suggestion at the end is this, that provisions which should be amended should be such that it should be capable of only one interpretation, not more than one interpretation. Otherwise, with brilliant arguments of the advocates, the poor judge has to accept one or the other argument of the advocates, and he takes a particular view. We should not make the arbitration law complicated. Thank you very much, Nitin Bhai, for this opportunity.
Thank you, Justice Dhanuka. May I now request Mr. Khambhatta to kindly address our members, please.
Chief Justice Dhanuka, and I'm so glad to be able to address you as that. Nitin Bhai, Venki, Vishal, and all my friends. This is such an important topic actually, because as the Indian economy grows, and we all know how well our economy is doing and what it will have to do in the future, dispute resolution of commercial disputes becomes more and more important. Now, for a variety of reasons, and rightly, our courts and judges are overburdened with so much other litigation that if this sphere was also brought back into the courts, the system would not be able to cope. So therefore, arbitration fills a very important space, and it's important to keep on looking at the law of arbitration to make sure that it provides a fair, speedy, and reasonable remedy to people who have commercial disputes. I have heard with great interest Justice Dhanuka's suggestions, and so many of them are so useful, so I feel a little daunted now following. I'll try and also pick off a few that I thought of. Some suggestions are really only housekeeping or clarificatory, because the Supreme Court has already decided points, and I think the Act just needs to reflect some of those. But some might provide a directional change. But before any of that, I must say that I think by and large, our Arbitration Act today is working well. I don't think there are any major problems, and I think especially after the 2015 amendments, I think arbitration has taken the right direction here. So it's important not to make too many changes and constantly tinker around with sections, because that also makes for less certainty and predictability. That said, the practice in many countries, such as Singapore for example, is to constantly review and make changes if necessary in their laws. Let's really start from earlier sections. The definition of party. Now, here of course we have the whole group of companies doctrine coming in, and which has caused some uncertainty in our law. Of course, the Supreme Court Constitution bench has reserved judgment and will be deciding on that. But I think, of course, depending on what the Supreme Court says, perhaps the definition of party should be amended to now include not only a signatory party, but any other person who is contractually bound by that agreement, who have not either expressly or impliedly consented to that contract. So some clarification there I think is necessary. In 2(1)d, arbitral tribunal now must include emergency arbitrator after the Supreme Court judgment in Amazon. But we must also remember that Amazon dealt with a Part 1 arbitration. It still doesn't solve the issue about what happens if in a foreign tribunal an interim order is passed or an emergency award is made under a foreign institutional rule or in an arbitration seated outside India. Now that is a more vexed question, because are you then giving immediate recognition and enforceability of even an interim award before the final award is made and before going through the entire process of Part 2? And therefore what I would suggest is we follow by and large a time-tested route, which is that you can bring that interim or emergency award to a Section 9 court. And a Section 9 court, therefore, I would suggest adding one more subsection to 9(1), saying a Section 9 court can also pass appropriate orders for enforcement of interim orders made by tribunals or emergency arbitrators seated outside India. That will make it very clear that that's the route to follow. And of course, the Delhi High Court and our court has done some good work on this to suggest that by and large, a party should not get two bites at the cherry. So our Section 9 court will not sit in appeal, but will only adopt broad standards as to whether the emergency or interim award was necessary to protect the subject matter of the arbitration. There's one other aspect of Section 9 which I think we should be looking at. A lot of parties rush to court with a Section 9 application, and very often a court gets drawn into the dispute and holds a mini trial to decide the prima facie case and all sorts of issues. Now, there is a risk in doing that, and the Gujarat High Court in a division bench judgment in the Asila Mittal case alluded to that risk. The High Court said, and rightly, that if right at the beginning, sometimes even before a tribunal is constituted, you have the supervising court make observations, albeit prima facie, on various issues in the matter, then is there not some kind of a subconscious pressure you exert over the tribunal that they must decide the same way even finally? Of course they are not bound to, but we all know the impact of a High Court order, even under Section 9, on a tribunal. So initially the law has already put in 9(3), which is that a Section 9 court will not entertain or entertain an application under 9 if the tribunal is already constituted. Now the Supreme Court interpreted this in a matter to say entertain means first entertain, and if it has already heard a matter, it can then pass orders. I would suggest actually that we should amend 9(3) to say a court shall not make any order under Section 9 once the tribunal is constituted, because that's really the province of the tribunal, and this will not only reduce the burden on our courts, but will also ensure that ultimately in the arbitration the tribunal gives its own independent view and is not pressured, even subconsciously, by something the court may have said. One of the safeguards I would also add to Section 9 is that a court must, before making any order under Section 9, record a prima facie satisfaction on two things. One, that an arbitration agreement exists. That's what Justice Dhanuka said, and I think that's right. And two, that the applicant is ready and willing to go to arbitration. But I have seen matters where Section 9 applications are made, they go on for weeks and months, and still no reference to arbitration is made. And we all know the section takes time. So you have a situation where sometimes an applicant comes to court, makes an application, gets interim relief without so much as even constituting or making attempts to constitute the tribunal. So I think that sort of party should be put on terms straight away, and the court must then record a prima facie satisfaction that the applicant is ready and willing to go to arbitration. Turning to section 11, again I agree with Justice Dhanuka that 11(6)(a) must be formally restored to the statute book, in the sense that there is a shadow over it. It's not yet been repealed, but the notification has not come. But that lack of clarity must go. Although the Supreme Court in Vidya Drolia has said that notwithstanding the repeal of 11(6)(a), the law laid down in Patel Engineering still stands, overruled legislatively by the introduction of 11(6)(a) in the first place, but that is unclear. Therefore, let us reintroduce 6(a) and with one small change, the 11 court to only a decision on the existence of the arbitration agreement. I would say we should restrict the 11 court to a decision prima facie on the existence of the arbitration agreement. So even an 11 court will not finally decide, but if it is prima facie satisfied, it sends the matter to the tribunal after appointing arbitrators. And I think it's a very wise suggestion Justice Dhanuka has made about when it is to appoint any arbitrator, calling for advanced disclosures of interest before the appointment is made so that there are no surprises later. Now that brings me to section 16. And 16 is really a huge advancement in our law, and it's a section which is somewhat, I'm really confused and puzzled as to why the Supreme Court gave the judgment that it did on stamping of an arbitration agreement. There was no great public interest or public policy involved in that, and I should have thought a simple resort to the theory of separability which you find in 16(1)(b, that even if the main contract is null and void, the arbitration agreement continues, would have been an easy answer to stamp. Now, we all know, of course, that stamp is on the instrument and not the transaction, but again, I don't think that causes too many problems, because an instrument is not a physical piece of paper. An instrument is a transaction recorded between the parties. Now, is it to be said that had the parties taken the precaution of having a contract on one piece of paper and the arbitration agreement on another piece of paper, you would not require stamping? But because they printed out that clause on the same piece of paper, the arbitration agreement is void? That can't be. It has to be the juridical nature of the document, that is to say that the transaction, the document comprises of a principal contract and a separate arbitration agreement. But again, therefore, that requires a quick amendment. Otherwise, it would really ride a coach and fall through many arbitrations. And all sorts of confusion strike the mind. Insufficient stamping, stamp rates may be different in different states. If you have a seat in one state, a venue in another, if you have to enforce the award in another state, this is going to cause chaos. And it's unnecessary. I don't think some great public interest is served by this. It's ultimately a matter of paying stamp. So I don't think we should really destroy so many arbitrations with this approach. But there's another part to section 16 that has always interested me. As Justice Dhanuka told you all, if you raise a jurisdictional objection before a tribunal and you succeed, then the other party gets a full appeal under 37 immediately. However, if you lose, that is to say the tribunal upholds its jurisdiction, then you have to wait out the full arbitration and undergo the cost, expense and time of a trial before you can challenge that determination. Now this actually is a departure, a rare departure that our law has made from the UNCITRAL model law. In the UNCITRAL model law, there is provision for an immediate challenge if your jurisdiction objection is rejected. Now, I am not suggesting we should go that far, but I do believe that when you are allowed to challenge at the 34 stage, the jurisdictional challenge has to be a fuller challenge than the limited parameters of section 34. Because inherently, a decision as to the existence of the arbitration agreement is factual. It would require evidence which you may have led before the tribunal. To restrict the 34 court to a position where even on the very existence of the arbitration agreement it cannot reappreciate the evidence, I don't think would be fair, because the existence of an arbitration agreement is the very source of the power of the tribunal. And as the saying goes, a tribunal can't pull itself up with its own bootstraps by wrongly deciding that an arbitration agreement exists, and then you're told that now only if it's contrary to public policy or if there's a patent illegality can you interfere with this decision. Now, many other jurisdictions have this. In England, for example, section 67 of their act permits a full de novo adjudication on jurisdiction, including leading of evidence before the court. Again, I don't think we need go that far. I think we should actually follow the line again that Vidya Drolia has suggested, that gateway disputes, and we should restrict gateway disputes only to the question of existence, a court must have a second look at when the matter comes to court. So perhaps we can have an amendment to 16, which says, on the basis of the evidence and record produced before the tribunal, a 34 court can itself adjudicate upon and determine whether or not an arbitration agreement existed. And we must limit it to existence, which must be made very clear that this can't extend to arbitrability, which is whether a dispute falls within the scope of an arbitration agreement. That must be left to the tribunal. So we would then bring our law into alignment with most other countries, where as far as existence is concerned, a court has a second look. As far as arbitrability is concerned, a court defers to the tribunal and will only set that aside within the strict parameters of 34. I think this is necessary, otherwise sometimes it could be susceptible to misuse, to draw people into arbitrations which they have never agreed to go into in the first place. It could even be as basic as a forgery of a signature on a contract. And if one is told that the 34 court cannot reappreciate the evidence on the proof of that signature, then a person who has never signed an arbitration agreement might be dragged into a long arbitration. 29A. I must confess one thing. Yes, I was on the committee of the Law Commission which made its 2 reports dealing with proposed amendments at that stage, which ultimately resulted in the 2015 amendments. 29A was no part of either of those reports. We'll see it. 29A came in later at the suggestion of the government, and I must confess, when I was asked by Justice A.P. Shah, I was against it. And I said, you cannot impose an arbitrary time limit. My suggestion at that stage was, if you want to encourage institutional arbitration, you could have a time limit for ad hoc arbitrations, but say if they are managed by an institution, you must leave it to the institution. And I think that was Justice A.P. Shah's view as well. But he said, no, this is something that is being insisted upon. So I have to now confess that I was wrong. I think 29A time limits have worked. We have to recognize that. I totally disagree with 29A4, the proviso which Justice Dhanuka spoke of, which is this question of reduction of fees. I think that's really unnecessary in a statute. That must be deleted. But the rest of 29A, I think, has worked. And we have to evolve solutions that are unique to our system and things that will work in our system. And in India, most arbitrations are ad hoc. You don't have the supervision of an arbitral institution. And therefore, it's necessary to have some time frame within which arbitrations get over. But I must, of course, tell you, dispelling this common myth, that arbitral institution-run arbitration is not more expensive than ad hoc arbitration. I would actually venture a bet that it's cheaper. Yes, you don't have that big lump sum fee that you pay to the institution, but a well-run institution will make sure your arbitration is conducted efficiently, gets over within a particular time frame. And so the money you save in that is far less than the fee you pay to the institution. And some institutions even have the practice of vetting of awards. They never rewrite the award, but they check the award for obvious basic errors. And if they find any, they send it back. I think that's an important safeguard, because very often a successful party suffers through no fault of its own, because the award has made a mistake or is badly written on some aspect, and the successful party then sees the award being set aside. So there are certain safeguards that institutions can give. Now 34. I think by and large the 2015 amendments to 34 have worked. But there are 2 or 3 small areas which need some discussion and debate. I'm not sure that they necessarily need amendment, but I think the committee should look at them. The first is the intrusion of administrative law principles into arbitration. Administrative law, as you all know, is the law that you apply to the executive or administrative authorities when they pass orders or take actions or make decisions. Being functionaries of the executive and ultimately answerable to Parliament, and being under constitutional duties to act without arbitrariness and with reasonableness, the standard you would apply to them is different from the standard you would apply to a contractually appointed arbitrator to decide a dispute. There are sufficient safeguards in the law of arbitration and the Arbitration Act to a completely arbitrary or illegal award. But to apply the standards of administrative law to arbitrations, I think we are going down the wrong path. And I speak in particular about the application of this concept of perversity to awards. A lot of us use this word and we see it in petitions all the time. Perversity is not something that you don't like in the award. The Supreme Court in Associate Builders has given a working test of perversity. So it is said, perversity means where you reach a finding without any evidence at all, or you reach it by ignoring vital evidence, or you reach it by taking into account irrelevant evidence. Now, there's a slight danger in this test. And the danger is this. I can understand a test where a finding based on no evidence at all is something that cannot be sustained. But if you ask the 34 court to decide whether certain evidence was vital or whether other relevant evidence should have been taken into account, then you are inviting the 34 court to assess the merits of the matter. And the explanation to 34(2) says a court should not go into the merits of the matter. So there is this inconsistency or contradiction. Now, the history to this was that in Western Gecko, when the Supreme Court decided to wholesale import administrative law principles, and in fact imported Wednesbury unreasonableness even into the law of arbitration, fortunately the amendments had not come in at that stage. And that is what caused a supplementary report to be made by the Law Commission expressly referencing Western Gecko and saying, no, you can't have Wednesbury unreasonableness, and therefore the explanation was suggested and accepted that a 34 court will not go into the merits. So far so good. But subsequent to the 2015 amendments, the Supreme Court has now held that perversity, which is no longer part of public policy because of that explanation in the statute, comes under patent illegality. Now, that puzzled me itself because I don't see how perversity can come under patent illegality. Patent illegality is a question of law and error of law. Perversity is inherently something rooted in fact. But be that as it may, if it comes under patent illegality, that provision, and if we just see 2A for a moment, 34(2)A, which deals with domestic arbitrations, does not have the caveating explanation 2. That is to say, there shall not be a review on the merits of the dispute. Now, if you just bodily put explanation 2 into 2 capital A, you're going to have a problem because perversity requires some review of the merits of the dispute. You can't come to a conclusion on perversity without doing that. So, some clarification, either judge-made or statutory, has to come, where perhaps the concept of perversity can be limited. And the Supreme Court did this in a subsequent matter, in Prismium, of course dealing with the foreign award. It added 2 caveats. It said this sort of a perversity must be something that goes to the root of the matter, and because of that, the result of the award has completely changed. That's one condition. And the second would be that it must result in a miscarriage of justice. So it doesn't allow a 34 court to start saying, is this evidence relevant? Should this be considered? Is it vital? Or why is the tribunal relied on this aspect of the evidence? We find it irrelevant to the merits. Those exercises must be cut out of 34. And perhaps some explanation limiting perversity to cases where there is no evidence at all to support a finding, I think, are in order. By and large, our courts have resisted this temptation, especially Bombay and Delhi. The judgments are very clear. But I fear other courts might not be able to resist this temptation and might use perversity to go into all sorts of matters which really are forbidden under 34. And I only refer you to a great passage of Justice Nageshwar Rao in Delhi Metro, where he says that what happens is that sometimes courts tend to dissect an award and re-envisage it, and then use these mantras of perversity to justify what they're doing. So that's an area which I think. The second thing I've always thought of under 34, again, this may add a little challenge to the process, but why can't we have an amendment to 34 on the lines of section 100 of the CPC? As you know, under section 100 of the CPC, a second appeal on a substantial question of law requires the court to formulate that question of law. Then parties will address on that question of law, and they can also address on the fact that this question of law actually doesn't arise. And section 100 also has the safeguard that if the court thereafter going into the matter finds that another question arises, it can always frame and formulate that question as well. Now, what if we adopt this approach to the admission stage of a 34? Instead of having a stage, and we all do this, if I appear for a respondent in 34, first thing I'll tell the court is I want to put in a reply. So then a reply comes in, a rejoinder comes in, then after a hearing of sometimes of some magnitude, the court says this will have to be finally considered, so we go to the next stage and the whole thing is re-argued again. Instead of that, what if you at the admission stage of a 34 without the filing of a reply? The court only applies its mind to whether on a demurrer, the 34 petition makes out a case under 34.2 or 2A. And it's not enough to say the petition raises a question of in conflict with public policy of India. Court should formulate, as it would under section 100, that by reason of this finding found in this paragraph, this is in conflict with the public policy of India, is a question. Similarly, patent illegality, because this forces the court to focus also and formulate the question and then let replies be filed. Now I know critics will say, oh, but then you're allowing someone to go and appeal from that. But so be it, because we assume the appellate court will be disciplined enough to say this is only formulation of a question. You can always argue against it at the final hearing. Because if that exercise is not carried out, more or less every 34 petition ends up being an argument going into the merits. I do it. I am the first to say that. You try and satisfy the court of the justice of the award and the evidence of the matter, and you go headlong into that, which is not the purpose of 34. So some focusing of 34 might be in order. The third aspect which Justice Dhanuka referred to is modification of the award. Now there's a very strong argument for giving this power to a court, no doubt about that, because there are awards I can think of where one has succeeded 90% in the matter, on one small issue, the whole matter you have lost because of that one issue, and that finding is patently erroneous in law. If you succeed in a 34 in getting that finding set aside, it doesn't mean that you get what you claimed in the award. You have to then go all the way back and restart the whole matter from scratch, which is really completely unfair. On the other hand, the other point of view is, if a power of modification is given, that may open the floodgates for courts to start interfering with awards and applying their own mind to all sorts of matters. So, on balance, I would be against giving such a power to a court. Yes, in many cases that would visit an unfairness, but in the larger perspective, you'd have less interference in awards. I would probably only suggest a power to a 34 court in certain cases like this, where it feels an injustice has been done, to immediately either reconstitute the old tribunal or constitute a fresh tribunal and make a reference back to that tribunal, limiting it to that question. So not reopening the whole arbitration again, where fresh evidence is led, fresh arguments are led, limiting it only to that error of law which it has set aside, or the patent illegality, saying the rest of the first award stands, we sever this portion and this refers back, can go back alone. That would be fair because you'd get an immediate redecision, and where you have succeeded on evidence, etc., there would not be a setting aside of that. So perhaps some evolution of the law there. There are 2 or 3 other matters which our law needs to incorporate. One is third-party funding, which is very common in international arbitration, and it's very important. I know we've all grown up in law college hearing these words maintenance and champati as if there's something bad. Under English law, they're treated as something bad. The old English law is no one can maintain a litigation by financing it, etc. But actually, experience has found that maintenance, financial maintenance or funding of a litigation is a good thing. Why is it a good thing? It's a good thing because if you have an impecunious litigant who has a good cause, but he cannot afford to fight it, that good cause goes by the wayside. Secondly, if someone funds, say, an arbitration, that person will be very careful. It will vet, it will filter out, it will analyze the cause. It will only fund good causes, it won't fund bad ones. So there's an automatic filtration process at that stage. And lastly, the funder, I can tell you, he is very, very particular about the performance of the lawyers, because it is hard-earned money put into a cause, so that itself improves the process. Now, contrary to what many of us imagine, third-party funding is not forbidden under Indian law at all. From Ramkurmar's judgment in 1872 of the Privy Council, third-party funding is completely permissible. The only exception is it should not be something to fund a vexatious litigation or to make an extortionate profit, and it can be done by the lawyers concerned, because then they are really funding a litigation for themselves. But with these exceptions, third-party funding, and recently the Delhi High Court has commented on third-party funding in a judgment, can be incorporated into our system to actually regenerate a whole number of matters which are falling by the wayside because the party cannot afford to actually go into arbitration. I'm not sure that should come into the Arbitration Act, but there is need for some regulation there. One other aspect I must point out. Again, this arises out of 2 judgments of the Delhi High Court on a totally different topic. You all must have heard of this expression, bilateral investment treaty arbitration. And for those who haven't, basically it's only this, that when large foreign investments are made into a country, the investor wants protection for that investment. He doesn't want to be left completely to the mercy of a litigation between him and the person he's contracting with. So governments, to encourage such foreign investment, started entering into treaties. They are government-to-government treaties, but they offer the investors of a particular country the benefit of an arbitration against not the individual who they have a contractual dispute with, but against the government of that country. So an individual sues the government in arbitration and gets his award on their various well-settled grounds. Now this is again a very controversial area because Some of these awards we feel have been unfairly made against India, etc., etc. But the fact is that this is a means by which you can attract investment, by giving a remedy. Now, internationally, there is something known as ICSID, which is an international convention, which gives automatic enforceability to investment treaty awards. So it's rather like our section 44A of the CPC. You just come with that award and a court will enforce. We don't have that because India is not a signatory to ICSID, which is a 1965 convention. In India, the award has to be enforced like any other foreign award if it is made abroad. And usually these are seated abroad. Now, recently the Delhi High Court in 2 decisions held that an international treaty arbitration award is not commercial for the purpose of section 44 of the New York Convention and our Act. As a result, the investor is left with no remedy effectively. He can't automatically enforce under ICSID, and if it's not a part 2 enforceable award, he has no remedy under our Act, in which case he has to file a suit to enforce that, which is meaningless. Now, if the government wants to give that remedy, and even in the model BIT, which is the renewed model of 2015, which makes it far more balanced than the earlier, provides an arbitration. If that's a meaningful clause, then you have to give that remedy of enforcement, and therefore perhaps a clarification under section 44 that investment treaty arbitrations will constitute a commercial dispute or matter is necessary. And I don't see that shouldn't be a problem, because under our Commercial Courts Act, if you read that long definition, there's an explanation that says merely because the dispute is with the government or a sovereign authority doesn't mean it ceases to be commercial, which is the basis on which the Delhi High Court has gone to say it's not commercial. So I think that's important if we really want to continue attracting investment and give investors a fair playing field. One broad comment, the Arbitration Council of India, if you read its functions, some of them may be broad enough for it to start functioning as some kind of a quasi-regulator. Now that's not a good thing. Arbitration ultimately is a matter of contract. And as long as the rules of the game set out in the Arbitration Act and well-settled law are followed, you can't have a regulators, including accreditation of institutions, accreditation or grading of arbitrators. I don't think this is a good thing. I don't think it subserves any public purpose. I would say that in fact, what the Arbitration Council should be doing, or should do, but it's not yet come into force, is something quite different. And that brings me to the end of what I want to tell you all today. Slightly off topic, but I want to tell you all this. It is the manner in which we practice arbitration. I must tell you that I have participated in arbitrations in India. In fact, probably my very first arbitration was junior to Mr. Divitri in a matter against RCF years ago. It's either that one or a matter against ONGC led by Mr. Saleh Doctor. Those two were my earliest arbitrations. I've also participated in international arbitration. I continue to do so. Now, I have seen that Indian lawyers, when we participate in international arbitrations, are really second to none. They have the expertise, the competence and the talent to hold their own. But where we do fall behind is in different ways. Internationally now the practice, whether by the lawyers or by the tribunal, is automatically and immediately transcribed in real time. There are 2 stenos who have special 8 key or 10 key typewriters, and their speed is remarkable. As you are speaking, you can see on the screen what you are saying. And this goes on the whole day, including for taking of evidence. Now, the advantage of that is that there is a black and white record. 34 courts, that is invaluable. No dispute that happened there. It's also invaluable during the arbitration because no counsel, and sometimes we are wont to do that, makes an argument in one direction in the morning and in a different direction in the afternoon. If he wants to do that, he has to admit that I'm sorry I went that way, I was mistaken, now I want to go another way. But he cannot feign ignorance and say, no, what I meant is exactly the same when he's arguing the opposite. It's there in black and white. The evidence goes much faster. Everything is question, answer, no separate recording. Now, one of the big criticisms we have is, oh, but it's very expensive. And yes, it is expensive because today the technology doesn't exist in India. Often you have to import these people from Dubai or Singapore and you pay a lakh and a half a day for that. But when you see the cost of big complex arbitrations which are held in India, the stakes that are involved, the lawyers' fees that are involved, the saving of time, because this reduces the time by at least 50%, if not more. The saving you'll make on the whole will be much more than if you didn't have this. So, I know the Delhi Center, which Justice Dhanuka and I saw, has introduced this. And I think this is one area where the Arbitration Council must start introducing it. The other area where I feel sometimes our practices are lagging behind is this myth that arbitration is completely ad hoc and discretionary and everything should be left to the tribunal without any clarity on what's going to happen. That's not how it works. Most international arbitrations start with the most detailed, what they call procedural order number 1. It runs into 4 or 5 tightly typed pages. It tells the parties the full roadmap for the future. What is the procedure to be followed? What are the rules to be followed? It may incorporate, for example, the IBA guidelines for taking of evidence, all that. So right from the beginning, you know the rules. Of course, everything is subject to the discretion of the tribunal. But then you can plan your entire strategy and your entire participation based on some certainty and not based just on an ad hoc decision at that point of time by the tribunal. Very important. Of course, there are other measures of detailed written submissions, etc. But that's another day and another talk. I think if the Arbitration Council starts inculcating these practices, and let me tell you, there are arbitrations seated in India which have already started this. I myself have participated in some, strict time limits, etc. I think there is no limit to what we Indian lawyers can do in arbitration and international arbitration. And I'll leave you only with those very wise words of Charles Darwin, who in his theory of evolution had said, if you remember, that it is not the strongest of the species, nor even the most intelligent of the species that survive. It is the most adaptable. The species that adapts to its environment is the one that survives, and I think we are now going into a new environment. We have to adapt to it. A few amendments to the Arbitration Act, yes, but we also, as lawyers now, have to evolve and adapt to international practices and maybe modify them to suit our environment, but move in that direction. Thank you.
I would like to sincerely thank Chief Justice Dhanuka and Mr. Khambhatta for taking time out from the Arbitration Act, and we have all benefited from their insight and incisive analysis. May I request a standing committee member, Mr. Farhan Dubash, to present a small token of our gratitude to Mr. Khambhatta. I would like to thank all of our participants today who are present here and who have seen this online for participating in today's seminar. Thank you so much. Please join us for tea and snacks. Thank you. Given what is it, if we have time, if you have any questions and comments, please feel free to ask one by one. I mean, you can raise your hands and we can take it from there.
Can I ask a question? Can you hear me?
Yes.
Or yes, without the mic. Actually, I have many more, but I'll restrict myself. We'll give you a separate section. This is in the context of Section 9. Justice Dhanuka was sitting in a division bench in the Valentine Maritime case,
where you held that the provisions of Order 38 Rule 5 are not strictly applicable when it comes to deciding a case under Section 9. This was affirmed by the Supreme Court. Thereafter, the Supreme Court came up with another judgment passed by Justice M.R. Shah, which was diametrically opposite to the judgment passed by the Supreme Court hardly 2 or 3 weeks later. Then both these judgments came up for consideration before Justice Dangre, and she came up with a middle path. Don't you think it is essential for Section 9 to clarify what are going to be the parameters for passing an interim order, whether 38 Rule 5 should apply, not apply? That's the question I have, because this is going to cause a lot of problems in other courts as well, because Bombay High Court judgment obviously is not going to be binding on other courts. And again, this matter will have to be taken to the Supreme Court for clarity. So that's the question I have for you.
See, it is clear that judgments are not to be read as statute. So that is why some of the amendments what I have suggested today is that whatever lacunas are created because of judgments should be made clear in the statute, so that capable of only one interpretation, one way or the other. I fully agree with you, judgments are inconsistent and it becomes very difficult for the single judge or the judges in the lower courts to follow one or the other judgment. There is no choice. The law of precedent of course applies. But if law is very clear, statute is very clear, then there is no question of any other interpretation. There should be one and plain simple interpretation.
Just one last question. Just one last. I hope I'm not monopolizing, but this is the context of Section 17. The arbitral tribunal has the powers to pass interim orders. Now, Section 36 in terms says that an award passed by an arbitral tribunal is deemed to be a decree of the court. But there is no provision relating to what happens to an order passed by the arbitral tribunal under Section 17. Now, if a tribunal passes an order, for example, injuncting a party from doing X, Y, or Z, or passes an order which has the effect of a third party not parting with funds, how is that going to be implemented? Because ultimately many parties may treat that order to be rather not exactly like a decree of a court. How would that have to be dealt with? Don't you think there should be a provision for that as well? Section 36. No, but how would it be implemented if parties are going to now disobey that order or not comply with it? There needs to be some clarity on that. Yes, but that's the problem. Again, we get into a situation where you have to then start getting into an implementation. If there's a provision in the Act to deal with a situation where parties are disobeying the order, especially third parties. Say if you pass an order against a bank, like a garnishee action, then how do you implement those orders? If there is some clarity in the Act to that effect, that's the question I have.
If you remember, earlier orders passed under Section 17, for enforcement of that order we were required to file petition under Section 9. And then 9 order will be enforceable. Very vast provisions for enforcement of order or for decree. We will have to invoke that.
Any other questions?
I just wanted to make a couple of points, I agree that the Act is, if you interrupt, it will be a long speech. I agree that the Act is good and, if you see the UNCITRAL, virtually the language is similar. Just to point out why 13 and 16 don't have the appeal provision like some other countries and under the UNCITRAL, the answer was simple, that to avoid knocking at the doors and getting the arbitration stalled. Now that comes to the root of the problem, that every time in an arbitration, if an opportunity is given, the courts are burdened, that's a fact. Every time an opportunity is given to go to court, is going to delay the proceeding in a long, long time, whether you go under 37 or you go under 34, and that causes a problem. Can we not suggest some mechanism, an alternative kind of forum or special commercial courts to deal with arbitration itself to expedite this entire process? Because as they say now, okay, even if you get an award,
only suggestion I give is that some good lawyers from original side should accept judgeship. Unfortunately, we are not able to convince. In my last speech also I said, we can only try to persuade, we can't force anybody to accept judgeship. And another thing is that you can always make a representation to the Honorable Chief Justice to assign more and more judges for arbitration. And whomsoever is given assignment, he should be given exclusive work for arbitration, not other subjects. That is making more difficult. Brother,
There is one instrument within the Act which might do what you want, which is 31 capital A, costs. Heavy costs should be imposed if there are frivolous applications filed, even under 31.
So I just want to ask Justice Dhanuka, you've been talking about this stamp problem. It's a serious problem because many arbitrations are frustrated. Would a simple solution be, forget the Arbitration Act, why can't you introduce an amendment to the Stamp Act saying that any arbitration agreement, whether incorporated in a larger contract or whether independent, will not require stamping? Wouldn't that be the simplest solution to the problem?
as far as Maharashtra is concerned, there is no separate stamp duty payable on arbitration agreement. This is only because of the interpretation of the contract, even if it is forming part of the main contract or independently. The argument of section 16 is missed unfortunately by Supreme Court, with great respect.
Every state will have to have it.
What we can do is, there are a couple of participants who want to ask questions. So we'll take 2 questions and then get the mic for our speakers.
Yes. So my question is, can the claimant invoke fresh arbitration when section 34 petition has set aside the award and there's 37 appeal pending in court, which we know it takes a lot of years for 37 appeal to be heard. So whether fresh arbitration should be invoked, and is it all right, because 2 parallel proceedings is not something which is in the interest of either party.
Anyone else? I think the question.
Good afternoon. My question is the context of Section 34. Section 34 has been narrowed down over the years to the extent that even incorrect application of law cannot be interfered. Now my question is, can an award be kept at such a higher pedestal as opposed to an order of the court also? Like there are broader grounds to challenge an order as opposed to a Section 34. Justice Dhanuka did mention it will amount to a first appeal. But my question is, like, 34 is so narrow as opposed to challenging an order. So any thoughts by either of the speakers?
See, there are judgments after judgments, and Supreme Court judgment gives you both the parameters, when award can be set aside and when award should not be set aside. So, on the ground of perversity, patent illegality, there are judgments after judgments. Even in 2023, recently, the Supreme Court judgment has come when the award can be set aside. The last important judgment was in case of Samsung, where in one paragraph Supreme Court said that even if there is the vital documents are not considered, award can be set aside under section 34. But in the same judgment there are other parameters also, so you have to see. And there should not be any unnecessary interference. I agree with my brother Mr. Khambhatta that otherwise the whole purpose of arbitration will be frustrated. It should be a gross case. And all these grounds of section 34 are interpreted by courts in different way. which will be apt for your matter, that you will have to read the judgment and apply it.
There is a good reason why there's a difference in standard. Because when someone goes to court, there's no choice. Anyone can go to court, file a suit, and you have to appear, and a decision is rendered, therefore you have a full appeal. But arbitration is a matter of contract. It's the party's autonomy to decide to go to arbitration or not. So they choose a remedy where you have this very limited challenge. It's a matter of choice. That's a very vexed question, because if you have succeeded in the 34, award is set aside on some ground. Now a 37 appeal is pending from that. In the meantime, there is no, strictly speaking, there is no bar to your making a fresh claim. But what will happen if in the 37 appeal, the 34 order is reversed and the old award is restored? Therefore, you really can't have a situation of parallel remedies like that. The appellant can then also refer to arbitration. That would lead to a lot of complication.
This concludes our question and answer session. Thank you for joining us. Please join us for tea and snacks. Thank you.
Bye.